Hello, my name is Professor Victor Lopez, and today I would like to provide a very brief lecture on an introduction to copyright law. For those of you who may not be familiar with the topic, I'd like to give you just a very brief introduction. The genesis of copyright law in the United States comes to us from Article 1, Section 8 of the U.S. Constitution, which gives to Congress the power to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, end quote. Congress exercised the right to create a Copyright Act first in 1790, which was signed into law by President George Washington. It was very brief and to the point. Unlike the current Copyright Act, it actually fit on a half page of a newspaper at the time when first printed. And it provided protection for authors, for charts, maps, and books that they had written for a period of 14 years that was able to be extended for an additional 14-year period at the option of the authors. The current version of the Copyright Act, by contrast, is 266 pages long. And that is not including the 12 appendices. So, as is the case with so much of the law, it has gotten significantly more complicated. But the good news is for authors and artists and others who are interested in protecting their intellectual property in the creations that they produce. Copyright is still relatively straightforward, and unlike other forms of intellectual property, specifically if we're talking about patents and trademarks, for instance, which are rather complicated in terms of the process for applications, and in particular for patents, time-consuming, expensive, and not easy for the average person to do on their own. Copyright, on the other hand, is actually very straightforward and also very inexpensive, also unlike the process for protecting patents and trademarks. An individual can copyright all of their works if they want to do it in a single application for as little as $35 if they're willing to apply online. It's relatively straightforward and inexpensive. But there's even better news than that, because the reality is that copyright attaches automatically once a work is created and saved in a permanent form, as we will see. Subject matter of copyright. Copyright is by intent relatively broad-based. It covers, quote, original works of authorship fixed in any tangible medium of expression now known or later developed, from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device, end quote. This is from the current Copyright Act, which appears in 17 United States Code, Section 102A, 2006. That is the latest as of this writing, anyway. And the coverage of copyright, again, is very broad. It covers all literary works, whether one is dealing with a novel, a work of fiction or nonfiction, poetry, uh, anything else that an individual creates that is of a literary nature. It can be protected by copyright. So can musical works, including any accompanying words. So both the lyrics and the music are subject to copyright protection for the author. And so are dramatic works, including any accompanying music that may go with them, such as background music that is created by the author, or if we are dealing with a musical, for instance, obviously an integral part of the work, that also is subject to copyright, as are pantomimes and choreographic works. Something that is probably not immediately obvious to the average person, but if you are an artist, a choreographer that is in the business of basically creating new dance steps, whether it's for a musical or whether for a Broadway show or simply for the sake of creating a new dance, as long as the work can be expressed in a physical form and either videotaped or the actual steps for the dance moves can otherwise be articulated either in writing or again in film or in photographs, the work can in fact be subject to copyright protection. Likewise, pantomimes. So if you are a mime, and even though for obvious reasons you're not going to be speaking during a performance, a mime's performance can be videotaped or otherwise explained in a way that can be saved for posterity, if you will, either with written explanation of what the mime's particular routine is, or with more appropriately with perhaps a videotaping, a taping of some kind that shows the mime's routine once the mime performs the routine, and this is now saved onto a video format of some kind that would be subject to copyright protection as well. Pictorial, graphic, and sculptural works are also subject to copyright. So if someone is a photographer and they take photographs of nature or people or anything else for that matter, the photographs are subject to copyright protection. And that is probably not a surprise to anyone. So are graphic artists who can create graphic artwork, that is subject to copyright protection as well. Also, probably no big surprise there. But sculptures are also copyrighted, and that is, again, probably something that the average person is not aware of. So if you are a sculptor and you create a sculpture, either modern or traditional, lifelike or not, when the sculpture is complete, the work is subject to copyright. No one can reproduce that sculpture. They cannot make a duplicate of it in physical three-dimensional form, nor can they photograph that sculpture and reproduce it either to sell or to give away without the express consent of the copyright owner, who would be the person that creates the sculpture, unless it is a work for hire, something that would be discussed in a different chapter of my book. Motion pictures and other audiovisual works are also subject to copyright. Again, no great surprise here. Once a film is created, it is automatically subject to copyright protection because it is, in fact, saved in a permanent form, the film itself. And likewise, audiovisual works, including, by the way, this presentation, this PowerPoint presentation, the writing as you see it presented here, as well as my narration. Both are copyrighted. Not that they have any significant value necessarily, but they are subject to copyright protection. And so are sound recordings of any kind, whether we are dealing with recording music or whether we're recording a performance of some kind or whether one records the sounds of nature for that matter. the nice sounds of the ocean at night, or a thunderstorm, or a rainstorm. Those recordings themselves are copyrighted, even though they are natural sounds. Capturing those sounds imbues the individual who captures them with a copyright so that no one else may reproduce that particular tape unless they have permission to do so. And likewise, architectural works. An architect who designs a new plan for a home has a copyright on that particular design. No one else may copy it without the express consent of the architect. Otherwise, they would be in violation of copyright law. Protection of copyrights. Copyright attaches automatically to original works of authorship that are fixed in a permanent medium, which means any work of authorship that is saved in a way that can be reproduced in the future and either seen or heard, viewed by third parties. How that is saved really doesn't matter. It can be using any current technology, something as simple as a pencil and paper, or electronic media, recording or photographing or taping, video taping something. Any of those would constitute the fixing in a permanent medium the work of authorship, which would automatically imbue the work with copyright protection. Notice that in a permanent medium doesn't necessarily mean permanent. One can scribble a poem with pencil on a loose leaf paper, and it's pretty obvious that that will not last forever. Eventually, the writing may become illegible, or the paper may degrade, but it is considered permanent for purposes of the Copyright Act. Likewise, if you tape something on a cassette tape, cassette tapes don't last forever. They do degrade, and eventually it will no longer be able to reproduce the sound. Nevertheless, when something is taped on an old cassette tape or reel-to-reel recorder for that matter, it is considered a permanent medium. Likewise, if something is saved on a recordable CD, CDR or a DVD-R or DVD-RW, or for that matter, a Blu-ray disc, the more modern technology, or a thumb drive. Any of those will not last forever. They will, in fact, eventually degrade. I believe, if memory serves, that if you save something on a recordable DVD or recordable CD, that they're really only supposed to last somewhere between 25 and 50 years. Eventually, they will become unreadable. It doesn't matter. It is considered to be permanent. If the original folks that inscribed the Code of Hammurabi on the original stels that still exists in the Louvre Museum in Paris, France, that was done more than 3,000 years ago. Nevertheless, it still exists, right? It is permanent. In fact, chiseling something on stone is much more permanent than recording something on a DVD. But both would be perfectly valid in terms of creating copyright protection. Protection does not attach upon the creation of a work, in other words, but only upon it being fixed onto a permanent medium. So, for example, if I am a poet, and I do write poetry actually, as well as fiction, in addition to my serious writing, the textbooks and the scholarly articles, I do like to write poetry. If I am walking down the street reciting a poem that I am creating as I go along, uh, the poem is not copyrighted as I speak it. If others hear it, or if nobody hears it, it makes no difference. The poem is not going to be copyrighted until it is fixed on a permanent form. Which means hopefully I have a good enough memory that when I get home or when I get to the office, I can sit down and type out the poem and save it on my hard disk or print it out on my laser printer or scribble it on a notepad. Until it is fixed in permanent form, that poem does not have copyright protection. It doesn't mean that other people can copy it and use it freely, because as soon as I do write it down in permanent form, then it does have copyright protection. And if I can show that I am the person that first came up with that poem and someone else tried to steal it, I still would be able not only to have copyright protection, but to register it with the Copyright Office and have a superior right to anyone else. But the point is, the copyright does not attach until the poem is actually saved in some permanent form. On the other hand, if I take out my iPhone and I choose to record a message and then I start taping the poem as I write it, or rather as I read it, it will be copyrighted as soon as it is recorded. Whether it's complete or whether it's a work in progress, because recording on my iPhone is a permanent form of saving the work, which would imbue it with copyright protection. Exclusive right in copyrighted works. Copyright gives the creator, the copyright owner, assuming that the creator and the owner are the same, which are not always the case, by the way, because you can create a work under a work for hire arrangement and the author may not actually be the copyright owner. For example, I have written, I guess, about 6 textbooks at this point. And all of them have been works for hire, which means I am the author, but the publisher is actually the copyright owner. So even though I create the textbooks, my publisher owns the exclusive right to reproduce them, and I cannot even give copies of the files containing the textbook to my students free of charge if I want to do that, because I will be in violation of copyright. I don't own the copyright, the publishers do. Uh, that's true for my early textbooks back in the 90s, and it's true for the textbooks that I write today, except that when they are no longer published, then under contract, the copyright reverts to me, and I would be able to offer it to another publisher or even to self-publish if I wanted to do that once they are no longer published by the copyright owner. But if you don't have a reversionary right, which is something important for any author to consider, then the right doesn't revert automatically. So you may write something, whether it's the great American novel or whether it is, for that matter, a film that you are creating under a work for hire arrangement where the studio is going to own the copyright, and you'll be entitled to royalties, of course, or you may be entitled to a lump sum, whatever you negotiated, but you will never own the copyright unless there is a reversionary right to it, or unless the author reserves the copyright and only gives the publisher a right to publish, or a first right to publish. Very unusual when it comes to textbooks, not at all unusual when it comes to other forms of book writing. The owner of a copyright has the exclusive right to do all of the following, and to do or to authorize others to do. any of the following. The first is to reproduce the copyrighted work by any means. So the person who owns the copyright can give copies away. They can post it online. If it's something that exists in a word processing file, they can give away copies of the file. They can sell copies of the file. They can rent copies of the file for individuals, for a fee, completely up to the individual, but only the copyright owner is able to reproduce the work in any means. When you buy a book, for example, you are not buying the copyright to it. You are simply buying the physical book, which gives you the right as the owner of the book to give that book as a gift to someone else. That is not copyright infringement. However, you may not make a copy of the book or a copy of portions of the book and give it away as a gift, or post portions of the book online for others to read. You don't own the copyright. You simply own the physical copy of the book. It's even worse when you are getting an ebook, because you have to look very carefully at the terms of use, and usually it is a license that you are given to view the ebook and to download it to one or more electronic devices that you may have, like book readers or computers or tablets or smartphones, but not to give it to someone else unless there is a specific right reserved for you to make a copy of that and to let someone else temporarily read it as well. With some ebook providers like Amazon, for instance, you may have that right. You may be able to allow someone to lend someone your ebook. In some cases, you may only do it once, and you may only do it for a 2-week period. With other providers, you may not have that right at all. In fact, downloading the book more than once may be copyright infringement as well. So you have to look very, very carefully at the terms of use. When it comes to physical books, when you buy the book, you have the right to resell it. You have the right to give it away. You have the right to burn it if you choose to do that. The book itself is yours, but not the copyrighted material that appears in it. That you may not use in any way other than to read it for yourself. You also have the right as a copyright owner to prepare derivative works based on the copyrighted work. So if you are Herman Melville and you write what many consider to be the great American novel Moby Dick, during the period of your copyright, you can be the only person that can create a derivative work based on your novel. So not only can you prevent other people from copying in part or in whole the novel that you wrote, you can also prevent other people from reading it in public. That would be copyright infringement. Can also prevent other people from creating an ebook version of your novel, had those things existed back in Melville's time. And you can even prevent a movie like Jaws from being created. You can sue for copyright infringement if you can show that the movie Jaws is really just a derivative of the Melville novel Moby Dick, which it pretty clearly is, right? Now, Jaws does not violate Melville's copyright because the copyright expired long before, Jaws was created, the series of movies, and therefore it is in the public domain and anyone can use it for any purpose they choose as long as they if they're going to actually be making copies of the work, as long as they attribute it to the original owner, they have a right to do that. You can get a copy of Moby Dick and you can do a dramatic reading. You can tape that and you can sell that if someone is willing to buy it. You can also make actual copies of the novel and sell it as a hard-covered book or as a soft-covered book, or put it free online as an ebook or anything else that you want, because the copyright has expired. While the copyright is still valid, however, you may not do any of those things. Uh, Another right that comes with copyrighted works is the right to distribute copies of phone records, or phonorecords rather, as they are known, which basically means, in the modern parlance, audio books, right, primarily, or music CDs, or streaming music services and so forth. You can sell, lease, rent, or by any other means reproduce a phonorecord, just as you may a book. Where literary, musical, dramatic, or choreographic works are involved, or pantomimes, motion pictures, or other audiovisual works, the right to perform the copyrighted work publicly is also exclusively the right of the copyright owner. So if you are William Shakespeare, and if you still had a valid copyright that had not expired because you just wrote, Romeo and Juliet, yesterday, only William Shakespeare can put on the play. Only William Shakespeare can create books, if he chooses to do that, or audio recordings or films of the play, because he owns the copyright and all its derivative forms. In fact, if you wanted to make a musical version based on the work, you would not be able to do that. So, West Side Story is a derivative work, and it would be copyright infringement. Again, except for the fact that good old, Bill Shakespeare's copyright has long expired. So you're more than welcome to put it to music, and to have the Sharks and the Jets go at it. Okay, not a problem, because copyright no longer exists. But if it was still a copyrighted work and the copyright were still valid, then West Side Story would in fact be an infringing work, just like I would argue Jaws would be an infringing work of Melville's Moby Dick. In the case of sound recordings, the copyright owner also has the right to perform the work publicly by means of digital or analog transmission. So if you have a sound recording of a record that you've created, and the music, or a dramatic performance, or a book on tape, for instance, only the copyright owner has the right to digitally transmit it, or to transmit it via analog means. So you cannot copy it, you cannot put it online, you cannot broadcast it over a radio station, you cannot broadcast it over a television station, etc. The exclusive nature of these rights means that no one but the copyright owner may copy, distribute, publicly display, publicly perform, or create derivative works that are based on the copyrighted work. It is a very extensive and very restrictive list of powers that are reserved to the individual that creates a copyrighted work, or one that purchases the copyright itself, or a work for hire if copyrighted work is created for a company or an individual. Before I move on to copyright infringement, I didn't put it in the PowerPoint presentation itself because it's not on Chapter 1, it's in a later chapter, but I think it's worth mentioning here that the duration of copyrights today is certainly much, much longer than under the original Copyright Act that I mentioned previously. It's no longer 14 years renewable for another 14-year term. Works that have been created after January 1, 1978 will actually last for the author's life plus 70 years if they are created by an individual. So the entire life of the author and 70 years after the author's death, all of the rights that I have described so far will remain with the author or with the author's estate. It is something that can be, bequeathed to someone after death. If it isn't, it's simply a part of the author's estate, and for 70 years after the death of the author is still entitled not only to collect royalties if the work is still being sold, etc., but also to license and to prevent others from using the work in any way that the estate does not want the work used. 70 years after the author's death, and if you have two authors, or more, the copyright will last for the longest lived author's life plus 70 years thereafter. So if you have a work that is created by someone who is 90 years old and someone who is 100 years old and someone who is 20 years old, in the normal course of events, if the 20-year-old, still lives an extra, 70 years, that copyright will be valid for all three for a period of 70 years after the longest lived author dies. So in the example I just gave you, copyright would be valid for another 140 years. It is a very, very long time. If works of authorship are not owned by a particular individual, but rather they are owned by a company, or they are published under a pseudonym where you don't, have the actual name of the author, or necessarily if it's published anonymously, if you don't know who the author is, the work will last for 95 years, either from the date of first publication or 120 years from the date of creation, whichever comes first. So this applies primarily, again, in the real world to works for hire that are owned by a publisher or by a movie studio, etc. Okay, if an author has transferred all of her rights to a publisher, or if it is a work for hire, which means that automatically it is the publisher that's going to own the work, or the studio if it's a movie, for instance, the work will be copyrighted for 95 years from the day of its first publication, or 120 years from the date of creation, whichever comes first. So you have an author who at the age of 20 creates a novel, writes it, and it is now copyrighted even though it isn't published, because when you save the novel on in permanent form, whether it's on a computer or on traditional paper, etc., you have a copyright, right? So the 20-year-old actually sells the rights to this novel when he is 90, and he sells it outright to a publisher who is now going to be the copyright owner. Well, in that particular case, the copyright is not going to last for 95 years. It will last for 120 years from the date of creation. So it was created when the author was 20 years old. It was sold 70 years later when the author is now ripe old age of 90. He finally gets to publish his novel, and he gives all the rights to the publisher. So it's going to last for 120 years from the date of creation. which means that the owner of that copyright will only have 50 years to enjoy the exclusive right of copyright ownership, because again, the novel was actually copyrighted 70 years before it is published, and therefore it will only last for an additional 50 years, 120 years total, whichever comes first. Moving on to copyright infringement. There are both civil and criminal copyright infringements that can occur even when unauthorized use does not bring a material benefit to the infringer. Many people are under the mistaken belief that as long as you are not profiting from someone else's copyright, you're free to use it pretty much any way you like. Okay. That is a very dangerous misconception because that is certainly not the case. There are criminal penalties for willful infringement. This is something that I cover later on in my book, and it's beyond this simple introduction. But there are also civil penalties that can attach, even when someone is not intending to profit from the copyright infringement, but they do it innocently, unaware of what the law is, and they don't profit from it. So, for instance, if someone finds a short story online that they believe to be in the public domain, or it says that it's copyrighted, but because they found it online, they assume that it's fair game and anybody can access it. So the person finds it and they print it and they give it away to friends because they really like the short story. That's copyright infringement, and that person is going to have to pay damages if they are sued for infringement. And these can be substantial depending on the circumstances, and it's something that individuals need to be aware of. Ignorance that something is copyrighted does not prevent an individual who owns the copyright from suing the person for misappropriation of the copyright. You have to be very careful when you use material that you believe to be in the public domain. You better have a good basis for that belief. The fact that you found something online and that the site where you found it claimed that it was in the public domain doesn't mean that it's in the public domain necessarily. So you have to be very careful when using material, especially if it's being used for a commercial purpose. If you're going to be, taking something and putting it as part of a book that you're writing and, selling it, that's a problem because you can be subject to criminal penalties. It's something that individuals need to be aware of. There's an awful lot of infringing material out there. Again, beyond what I can get into here, but there are safe harbor provisions for individuals who in good faith host an online service, and someone puts infringing material there. As long as they remove the material when they are told that it is copyrighted, they can avoid liability as a general rule. But individuals who take that material and use it are not going to be subject to a safe harbor provision. So again, pays to be cautious before using images or printed material or audio or video material that is available online. It's not always clearly marked as copyrighted, and the assumption should always be if you didn't create it, it's probably copyrighted by someone. So again, both civil or criminal penalties can be exacted depending on the circumstances. Making an unauthorized copy of a music CD or an audio book to sell obviously is both criminal and civil infringement. But making a copy to give to a friend, to give as a gift, for example, is also copyright infringement, as is performing a copyrighted work publicly free of charge without permission of the copyright owner. If one goes out in public and decides to sing 20 of a person's favorite songs in public, and they are being heard in a public place, uh, that person is guilty of copyright infringement for every one of those songs that he or she sings. The fact that you purchase a CD or that you purchase a video doesn't give you the right to publicly display it either. Something else that most people are unfortunately unaware of. So if you have a streaming service and you lawfully download music and you play it in your own home and you play it loudly and it can be heard from outside, that's okay. That's fair use. That's not a problem. On the other hand, if you go outside and invite members of your neighborhood to come in for a party out in the open where anybody can come in, and you decide that you're going to play that music, publicly, that is copyright infringement. And one can be sued for that. Likewise, if you have a nice video projection system, I have two of them actually. Okay, I love movies and I love to see them on a large screen from time to time. Perfectly okay for me to project a movie that is coming to me from one of the several streaming services that I subscribe to, or that I have bought. I have a large number of movies that I've bought that I own on Blu-ray discs and on traditional DVDs. I can certainly project that movie for my wife and me to enjoy as many times as I want within the privacy of my own home. I can invite friends, who happen to be there for movie night, and I can show the movie without being infringing on the copyright to my friends. And we can have a nice party and watch a large screen version of a recent movie that I may have purchased. However, if I go on my backyard and I set up a giant screen, like the old drive-in theaters, and I let the whole neighborhood watch the movie with me, I have a problem, right? That's copyright infringement. That is a public performance. And the difference between public and private is sometimes a question of fact. There are gray areas. What about in my backyard, but I have tall hedges and, no one that's not invited can actually see it? Is that infringing? Well, probably not. But it depends on the circumstances, right? And one has to be careful. There are limited fair use exceptions or limitations on the copyright owner's ability to prevent others from using their copyrighted material. There are a number of fair use exceptions. I cover that in chapter 2 of this particular book. But there are specific criminal and civil penalties for other types of use, and I cover those in significant detail in chapter 5 of this book as well. For now, just very quickly mention a couple of fair use exceptions. If you are going to be quoting from a new novel, for example, for purposes of literary criticism. You have a newspaper or you have a blog, and I just wrote my first novel, and you get a copy of it, and you think it is the worst thing that anybody on earth has ever had the temerity to publish, and you want to give an example of how terrible my writing is, perfectly okay for you to quote, maybe a half page, of dialogue or expository prose. Perfectly fine if it's a 300, page novel and you're using a half a page of it to show how terrible it is or how wonderful it is if you're dealing with maybe a new Dean Koontz novel or whatever. That's perfectly okay. That's fair use. Whether you praise or whether you torch something, it is perfectly acceptable as long as only a very limited amount of material is borrowed for purposes of literary criticism. Likewise, if there is an article in today's New York Times or in today's Wall Street Journal that I want to share with my students, I can certainly show that in class, a portion of the article or even a complete article from a newspaper, because showing an article for non-profit purposes like educational purposes is fair use. It doesn't prevent someone or it doesn't unduly infringe on the right of the newspaper publishers to sell their newspaper. Just because I showed an article from today's New York Times in my class doesn't mean that students are not going to go out and buy the paper because they've already basically had me show them the entire paper. Okay. About 20 years ago, it was not unusual for some professors to be in order, for the best of reasons, trying to really do right by their students. They would say, hey, look, I don't want my students to have to pay $150 for a book or $200 for a book. I can just sort of borrow here and there. I can get 10 desk copies of books on the subject that I'm teaching, and maybe I'll just borrow a chapter from each. And I will photocopy it, and I will, get the print shop to print it out, and maybe my students can pay $5 to the print shop to get this collection, and it's fair use, right? Because after all, each book had maybe 30, 40, 50 chapters, and I just borrowed one, so that's okay, right? And the answer to that clearly is no, it's not. And there have been a significant number of institutions of higher learning that have gotten into trouble for precisely that kind of creative borrowing of copyright under the mistaken assumption that it is, fair use. It's not fair use to take an entire chapter from a book. It is not fair use for that matter, to photocopy a chapter of a book, even if it is to give free of charge to students or to scan it and put it online. Absolutely not allowed. And trust me when I tell you that publishers will, in fact, bring lawsuits when they find that that type of use is happening. As I said, unfortunately, I can't even provide my own textbooks to my own students, which I would love to do, free of charge, because I don't have the right to do that. My publisher owns the copyrights. I don't use at present most of my textbooks in class. There's just one that I'm using for my immigration law class because it's a mini textbook and it's extraordinarily inexpensive, and I couldn't find anything else that I could justify making the students purchase. So, for $6, they can get the electronic version of my, primer on immigration law and compliance. But I would love to give it to them for free. I can't, because it's not mine to give. It's the publisher's book, and they charge, I think, something like $12 for the paperback. So it's extraordinarily inexpensive because it's a very, very thin book. But some of the other books, most of my other books are much closer to $80 or $100, still a lot less than the competing titles, but it's certainly not a nominal amount. I would love to be able to give those to my students, just posting them online, but I cannot do that. I would be sued if I did that by my own publisher, and rightfully so. Anyway, about all that I have for this brief presentation, which took a little bit longer than I intended. I tend to be pretty gabby today, I guess. So hope you enjoyed it. And if you are interested in any of my publications. Most of the scholarly articles that I have published are publicly available online as well as in print. If you're interested in downloading some of those, taking a look at what I've published, you can go to my webpage at victordlopez.com. And if you're interested in some of the inexpensive textbooks that are currently being published by my current publisher, Textbook Media Press, you can go to textbookmedia.com and take a look at them as well. Okay. Meantime, I hope you enjoy this and have a pleasant day. Take care.